purportedly recall Joe Keogh to the witness stand. Of course, this is still Fifth Third's case in chief. Their case has gone on all week. Mr. Keogh went through direct exam, cross-exam, multiple redirects, and of course, pursuant to Rule 611, it's within the court's discretion to avoid cumulative and repetitious testimony pursuant to Galloway v. State and United States v. Herrera, Indiana Supreme Court, Seventh Circuit cases, as well as numerous other authorities within the state. Typically, counsel is, and for instance, in Clark v. State is an example, in 1996 Indiana Supreme Court case in which the defense wanted to recall a witness and were not permitted to do so. And the issue there was simply that they had the full opportunity to present whatever testimony would have been elicited on the recall as they had during their initial opportunity with the witness. Rule 611 is, of course, the rule providing the court with authority to control the proceedings and is discretionary. With your honor, we would like to move forward with the City Center's case. We have Richard Plank, who will be here shortly, and would like to move forward with him.
Yes, Your Honor. We're calling Mr. Keogh this morning as the corporate representative in order to read in the request for admissions that were admitted in the discovery phase of this case. Second, Your Honor, if the court is in its discretion to determine Mr. Keogh should not be recalled in our case in chief, we ask the court to give us leeway to allow him to call him now, or we reserve the right to call him after the defense puts on their case, because we have a right to present arguments after they put their case on. So we thought for judicial efficiency it would be best maybe just to put Mr. Keogh back on, asking one is these requests for admissions which are completely different and separate from the issues that Mrs. Brandenburg is speaking about. Second is if the court doesn't want us to go beyond the request for admissions, then we'll just recall him after they put their case on.
What did you want to go into that you didn't want to direct?
Well, first is the request for admissions. We want to get them on the record as a corporate rep, not for the substantive, not for his testimony, but as the corporation is what they admit in the request for admissions. And then second, we wanted to get in a couple areas that were not out there, were not discussed in his direct examination.
Why weren't they?
What's that?
Why weren't they discussed?
Because we were going to, well, there's two reasons. One is because when we went back and read his deposition, we realized there might have been some inconsistencies in his testimony. And two is that we still had the right to recall him in our case in defending City Center's claim.
Your Honor, our agreement, we thought, was put each witness up once to save the jury all of this repetition and time. We did our direct when the witness was on during Fifth Third's case in chief. Fifth Third did their cross. If they found something in way of his testimony disagreeable, cross-examination and redirect was the opportunity. As far as requests for admissions, I'm not sure why Mr. Keogh would need to testify for requests for admissions.
Your Honor, I'm allowed to put a corporate representative on the stand to confirm that these are the answers to the requests made during the discovery phase. If the court determines that I'm not allowed to put a corporate representative on the stand for that purpose, I'm surely allowed to introduce in those requests and those admissions. Then I would ask the court to read in those requests and admissions to the jury as inclusive facts in this case. What's that? 6 or 7. Let me count.
I'll reserve it.
7. The second, Your Honor, is if it is counsel's position that we are not allowed to call Mr. Keel back in our case in chief, and that all the examination was going to be done when that party was called as a witness. Mr. Plank has already been called as a witness in this case. They had the opportunity at that point to bring him and to rebut his testimony. Therefore, Mr. Plank should not be allowed to testify a second time in this case.
Your Honor, Mr. Plank was subpoenaed. They told us they were going to call him live. They changed their mind the morning of. We canceled him to come out. We could not call him at that point. That was their case, and we could not call him. We can call him in our case. They read in his deposition. They didn't put him on the stand.
Your Honor, we've had an agreement that witnesses are going to be called once. Right? If they had something to refute in the deposition, they were required, pursuant to the agreement of the parties, to have Mr. Plank here and have him prepared to testify.
You want to tell them that they can't put their witnesses on?
What's that?
You want to tell them how to present their case?
No, Your Honor, not at all.
They didn't preclude you from calling any witnesses, did they?
We would have preferred that he'd been put on that morning when we had him planning to come. We let them put their case on the way they wanted to put it on.
Your Honor, I guess the thought process here is that if we're not allowed to call Mr. Keel back,
I didn't say you weren't allowed to call Mr. Keel back. I'm saying we're going to move on to reserve any decision on Mr. Keel and on the request for admission.
For rebuttal.
Maybe possibly go on to rebuttal. Or call them again.
Well, we're allowed to put our request for admissions on in our case in chief.
Well, sure you can.
Okay.
All right. You don't have to do it right now, do you?
Yes, we're going to do it right now.
If Mr. Woodward wants to read in the request for admission, I think he's certainly entitled to do that. I don't have an objection to him reading his request for admission.
I think that I could get a corporate representative to answer each request that was admitted in this case. And I'm asking the court to allow me to read in the request and have the corporate representative, Mr. Keel, answer, admit. Or I would ask the court to read in each request for admission and tell the jury that that request was admitted.
Again, the request for admission has been outstanding for several years, I would imagine, at least a year. If they wanted to do it in their case when he was on the stand, they could have done it as a part of that. I'm not objecting to them reading them in now. I think that's perfectly appropriate.
These are requests for admission?
Yeah, these are requests for admission. This is the answer, admit.
What's that?
I mean, if we just read them in, if you read them in, and we instruct the jury that these facts, these matters have been admitted to, and you read them in, what is the difference?
Your Honor, if that's the way the court would like to proceed, then that's the way we'll proceed in this case.
All right. Anything else?
Yes, Your Honor. We do have some additional exhibits. These are all within the court's ruling on judicial notice, taken on judicial notice of the court files, and all of these documents come out of the court files. There's only a few. We would mark as Plaintiff's Exhibit 107 the third-party counter and cross-claim filed by Fifth Third Bank against. Really, we're offering it because it's against City Center and Plank. It's also got claims in there against Hawk, but I think the parties have agreed those claims are no longer in the case. That would be 107. 108 would be the answer. Sorry?
That's 107.
The 108 would be the answer of City Center and the affirmative defenses of City Center and Plank. It also has the Hawk answer in there, but we're not offering it for purposes of the Hawk answer. Exhibit 109 would be Fifth Third's request for appointment of a receiver. 110 would be City Center and Plank's response to the request for appointment of a receiver. 111 is the TGS motion to intervene, asserting an interest in the property. And then 112 is the receiver's action and ejectment of Z-Grill for non-payment of rent.
Yeah. Sure. Those are legal briefs and statements by counsel. Those are part of the court's record. That's not evidence for the jury. It's not proper to put all the attorney's arguments and commentary in. That's not evidence in this case. That's part of the court's record for the court's consideration, not for the jury.
Your Honor, under Rule 201, we do need to offer it into evidence. We can. We do need to offer it into evidence in order for the court to take judicial notice of it. We are not offering any of these for the truth of any of the allegations or arguments. We're offering these for the fact that a complaint was filed against City Center and Plank, for the fact that Plank did not answer and City Center did, for the fact that there were proceedings regarding the receiver, the appointment of a receiver in which everybody participated, and the fact that the receiver did file an action and ejectment. And the instruction, the proposed jury instruction for the judicial notice will just say that they have to take as conclusive that this document was filed. We're not going to say that all of the allegations or arguments or anything are accepted as true, with the sole exception of the complaint allegations against Plank that were never answered and were entitled to an instruction under 8D that they were admitted.
Your Honor, I would just stand by my previous statement that, there's been testimony elicited that a receiver was appointed, that the jury's aware of that, and that's the proper way to do it. You don't put the pleadings into evidence. The court's record is what it is. We went through this in the pre-trial conference taking judicial notice of your record. I think that the record is well documented. The court has that record. We don't need to put it into evidence here.
What is the purpose of putting this in before the jury?
Well, counsel has objected to enforcement of Your Honor's judgment of April 4th, 2012, saying that City Center and Plank were not parties to that proceeding. They were, and these documents demonstrate their participation in those proceedings.
Well, Your Honor, if we're going to go back to that, I think Fifth Third has mischaracterized that ruling. The court determined that Fifth Third had priority over the subcontractor liens. That's what it was. It was not stating that Fifth Third's motion or their lien wiped out City Center's planning. There are three parts to the summary judgment motion. We've argued that ad nauseum at this point. Putting that before the jury is simply going to further infect that problem in the fact-deciding process that we're going on here. The court's denied that motion. We've moved on. It's in the record. If they want to appeal it, they can appeal it. But putting it in front of the jury at this point would not be appropriate.
Your Honor, the judgment is in front of the jury, and it went in with counsel's approval, subject to his, he wanted to preserve the right to argue the scope, his objection regarding the scope of the judgment. And that's fine. But one thing that is clear, the first paragraph of Your Honor's judgment says nobody came forward with anything that contested any of this. And because City Center and Plank were part of those proceedings, they had an opportunity to come forward. Secondly, there is appellate case law in Indiana that when you're in a foreclosure proceeding, a prerequisite is that there is a default on a binding contract. We don't get to foreclosure if there was no binding contract or default. So the scope of Your Honor's judgment is clearly going to be an issue.
Which again is not the issue that this jury decided.
I mean, it seems like it's just something that shouldn't be going before the jury.
Well, we would take a stipulation.
To the facts of what we're really trying to do.
We would take a stipulation that with respect to a legal issue like res judicata or collateral estoppel, Your Honor, to make that ruling, we wouldn't publish these exhibits to the jury, but we want them in the record.
again, I think the record, they've made their record. There's nothing to go back and redo with this jury.
They are part of the record.
What about the jury should be able to look at the complaint, our third-party complaint, cross-claim, and counterclaim against City Center and Plank, and their answer, or City Center's answer, Plank's lack of an answer. That does go to the jury, and the instruction should be that his failure to answer.
I mean, there's no pleading, the denial.
But he didn't do that. Plank did not answer.
And once again, Your Honor, we rehashed this count. I forget if it was one or two. Said breach of note by City Center. So my previous the previous counsel for City Center answered on behalf of City Center. The next count says breach of note by Hawk. They answered on behalf of Hawk. It did mention Plank in some of the subparagraphs of the claim entitled breach of note against City Center, but counsel thought he was answering what was asked. He asserted affirmative defenses. All of that has been merged into the pretrial order, which was entered back in I believe, was it February or March? You know, that ship is long since sailed. We're here on the pretrial order, which sets forth the facts and contentions of the parties. We've argued this, I think, 2 or 3 times.
Your Honor, counsel has not correctly stated what is in the complaint. Paragraph 22 of count 1 of the complaint. The City Center construction loan is secured by a continuing guarantee agreement executed by Plank. A true and accurate copy of the continuing guarantee agreement is attached and made a part hereof as Fifth Third Exhibit B. Paragraph 23. The continuing guarantee agreement executed by Plank provides that Plank absolutely and unconditionally guarantees and promises to pay Fifth Third the indebtedness of defendant City Center. Now, both of those paragraphs happen to have been admitted by City Center, but then 24 goes on. City Center denied this one, but Plank admitted it. Fifth Third is the holder and owner of the continuing guarantee, and defendant Plank has defaulted under the terms thereof. And if you look at the prayer for relief, which is on page 5, it says, wherefore Fifth Third prays for judgment against the defendants City Center Complex LLC, Richard M. Plank, an individual, and each of them for the total amount. And to say that this does not allege something against Plank just is ignoring the pleading. If you look at their answer, the answer of City Center is signed just on behalf of City Center. There is no answer on behalf of Plank. And we're entitled to have the jury take judicial notice of that.
As I said, Your Honor, the title of the complaint, which counsel skipped over, which is the point of my statement, count 1, City Center Complex LLC, breach of construction loan. As I stated, there are references to Plank in the subparagraphs, the paragraphs of that count, but the count is entitled City Center breach of contract. Same thing with count 2. It's Hawk breach of note. Now, once again, we've argued this. I think this is at least the 3rd time.
Yeah, I just believe that is just confusing.
Your Honor, the title does not control the allegations due in this case.
Part of the record, I don't believe they should.
Well, Your Honor,
at this point, part of the record.
there's nothing in the record that Plank failed to answer. There's an argument before Your Honor, and we've requested judicial notice. Rule 201B.
Well, it sounds like, it's almost like you're asking the jury to give you a default judgment.
Right. No, Your Honor. We are not asking for default judgment.
Well, if they didn't answer, what is it?
Well, they're admitted. That's what Rule 8B provides, and it is not a default judgment. We still need to prove our damage.
He's admitting that he owes the bank money?
That's correct. He did. When he did not answer. Rule 8B is not discretionary.
Has that ever been contested that he signed a note with all that money if they perform their part of the bargain?
If the jury determines that City Center's claim fails and that City Center's claim has no basis, that City Center breached and the bank did not, then I think they will be successful in their note.
Is that a stipulation? That if there's a breach by City Center, Plank is liable?
I think the facts are what is in the evidence. I'm not going to be bootstrapping
City
any.
Center, if there's a breach by Plank at City Center, then they're liable. I mean, that's the whole issue before the jury.
But we're being precluded from introducing the evidence that Plank admitted that he's in default of the guarantee. That's reversible error. 201B says it's got to be, it's mandatory.
Couldn't you call him and ask him not to understand?
That he failed to answer.
Yeah. Why do you fail to answer if you don't feel required?
Well, we can ask all those questions and this will come in as impeachment, if that's what you want.
Not what I want, I mean, I'm not saying to do it.
Your Honor, this is
There are other ways of getting these things in.
No.
This is an attempt to make an end run around the court's previous ruling. The breach of contract, breach of loan agreement allegations that Plank had a guarantee on, City Center denied. City Center said, we deny we breached. Plank's guarantee would only come into play if City Center is found to have breached. So what they're trying to say now is only City Center denied. We don't care about City Center. We'll just go right to Plank and have the jury determine as a matter of default that Plank is liable.
Your Honor, that's just not true. The guarantee is both a guarantee of payment and performance. It goes way beyond what counsel is arguing. And it is not us that's trying to make an end run around any ruling. It's counsel trying to make an end run around the clear requirements of Rule 8D.
And once again, the court's made that determination.
I made the determination.
Do any of these exhibits come in? Your Honor, we make an offer of proof.
All right.
If I may, let me just get them filed.
Okay.